I am Dr. G.K. Goswami, and today you are watching our this series particularly on corroboration and circumstantial evidence. We all are aware that circumstantial evidence are very important for corroboration in especially criminal justice trial matters and others. We know well that many a times the victim may not be available, victim may be killed, victim may be unknown or may not be traced, but there may be crime. So in those circumstances, corroboration become very important, and corroboration is done by way of circumstantial evidence. Even if there are oral witness, there may be eyewitness, but for the purpose of testing the veracity, whether the oral witness is reliable or not, for that purpose corroboration becomes very important. So friends, circumstantial evidence are key of delivery of justice. It enhances probity, it enhances trust in our justice system. So let's start how circumstantial evidence are important and how they play important role in corroboration. So let's begin with. So circumstantial evidence necessary for the purpose of corroboration. So when we start the beginning or we introduce this subject, we are aware about classification of evidence. There may be primary evidence, there may be secondary, and normally primary evidence are generally called eyewitnesses, and secondary witness or secondary evidence may be your forensic evidence, your recovery, your various other type of evidence which are very crucial. If we see doctrine of beyond reasonable doubt, this is the most important doctrine in criminal justice administration. So what did it say? That it is the duty of the prosecution to prove guilt beyond reasonable doubt, right? So if I say in simple terms, the purpose of trial is to evaluate that the person who is held guilty is beyond doubt, and secondly, no innocent shall be punished. So look few observations. Sir William Blackstone said that it is better that 100% who are guilty may be escort free, but not even a single person who is innocent may suffer. So the ultimate objective is to protect innocent person and to punish guilty. The emphasis remain on fair trial, and fair trial is the very important ingredient of rule of law. So if the government or if the judiciary fail to provide fair trial, then system collapse. So society needs trial and justice to be very fair and transparent. An accused is considered innocent until proved guilty. That is why it is called accused. Accused may be guilty, may not be. But once the guilt is proved, then conviction may be awarded, and the person is called now accused to convict. No one can be punished unless evidence eliminate reasonable alternative of innocence. So as I said, that trial is not only to establish guilt, but also to eliminate any possibility of innocence. And this is the key. Who will prove guilty beyond reasonable doubt? It is the duty of the prosecution. So it is prosecution to establish guilt beyond reasonable doubt. That's important. One important point, my dear friend, that guilty has to be proved beyond reasonable doubt, but the accused can prove innocence just merely based on preponderance of probability, which is basically lower quality of evidentiary value. So this is the difference. Prosecution has to prove guilt beyond reasonable doubt, while the accused can prove his own guilt, own innocence, just based on preponderance of probability. If we see the dynamics of the entire protection of accused rights is very golden doctrine, that is right against self-incrimination. Nobody can be compelled to be witness against oneself. This is very cardinal. Otherwise, if this principle is not there, then law enforcement agency like police may compel, may force, may even use third degree to admit guilt by the accused person. So burden of proof, proving beyond reasonable doubt. If we see this case, the most important case for any legal expert or maybe law students, Wilmington versus DPP. It is a very celebrated and hallmark case of United Kingdom House of Lords in 1935. Wilmington versus DPP. This was announced on 23rd May 1935, and legal question was who bear the burden of proving guilt. So the fact of this case were the George Wilmington, who was at that point 21-year-old boy, who was actually tried for the murder of his wife, and he said that he was just trying to, you can say, just to scare his wife to negotiate the domestic dispute, and by chance accidentally the pistol fire and the wife died. So he was convicted to death, and the appeal was filed before House of Lords. The legal question was who bear the burden to prove the guilt in this case. So Wilmington gave key principles which are cardinal to all jurisdiction. Presumption of innocence is the key, and every accused is considered innocent till proved guilty. Burden of proof lies on the shoulder of prosecution. So it is the duty-bound responsibility of the prosecution to prove guilt beyond reasonable doubt. What does it mean by proving guilt beyond reasonable doubt? It means that prosecution has to prove that a crime had occurred, that the accused committed it, and that it was committed with the required mental state or mens rea or guilty mind. The standard of proof must be beyond reasonable doubt. The exception, or you can say reverse burden, may be claim of insanity if disputed to be proven by the accused. That means somebody asks that what is the exception of burden of proof. So burden of proof exception may be on the accused if he claimed that he was insane, he has some mental distress or mental incapability. So who will prove that insanity? It is the accused who has to prove. Okay. So going further to connect corroboration on the behalf of the circumstantial evidence. Circumstantial evidence, my dear friends, they are indirect in nature, and if you take one by one, or circumstantial evidence may be multiple in number, we will go for the chain and or the rope theory and all. So they may be indirect based on the circumstance, because the circumstance speaks and you collect bit and pieces of the evidence and then means rope in a systematic chain, and chain should be unbroken. So it implies a fact or event without directly proving it. So there is no direct proof, but if you have seen the chain, there are the small parts of that chain. So they should be interlinked. There should be no breakage. need judicial interpretation to draw inference. Inference must be based on evidence and it helps arrive to a conclusion. So, circumstantial evidence generally they are indirect. In isolation they may look very weak, then they may not have direct proof. They are basically inferential in nature and they arrive in totality to a conclusion, either to prove guilt or innocence. So, mind it that corroboration may establish guilt as well as innocence. So, if we see the characteristic, they are indirect, they are inferential in nature, they may be compelling, means they may be very important if we see it in totality. They need completeness, chain of event. This is the most important part. The every chain that must be complete. There are various types of circumstantial evidence. It may be motive, then it may be any opportunity, it may be conduct prior to commission of crime, during commission of crime and after commission of crime. Then possession of stolen property. If somebody is found the property in his possession or in his place, then it is a circumstantial evidence that he is involved in that particular crime. Then scientific or forensic evidence. Yes, please understand that all kind of forensic evidence or expert opinion, they are circumstantial evidence. They are secondary in nature. Likewise, last seen theory or last seen together, that is also circumstantial evidence to corroborate innocence or the guilt. The purpose is basically to interconnect for the purpose of corroboration. So, it helps corroboration of facts. Even ocular testimony need corroboration and complete chain of events. Suppose a victim or a prosecutrix alleges that she has been raped by such and such person. So, she is the victim, so she is eyewitness also, she is prime witness, but if DNA is conducted and it link the accused with the crime, then it is the circumstantial evidence. So, there are various type of circumstantial evidence. It fill the dots. Many a times there may be some missing links. So, circumstantial evidence help to fill those gaps. Circumstantial evidence are panacea where no victim available, or it may be a blind case. Suppose you may get fingerprint, you may get CCTV camera, you may get many other circumstantial evidence which may help to corroborate the entire facts to lead to a conclusive decision making. Then circumstantial evidence, the admissibility part, how much they may be admissible. So, what is the conditionality for admissibility of circumstantial evidence? So, they need to have chain of circumstance which must be complete. As I said that all the parts of the chain, they should be complete. All the facts should make a single chain. Court must ensure that the facts are consistent, reliable and unbroken. If there is even a single breakage in the chain, then those circumstantial evidence cannot be used for the purpose of corroboration. For conviction, circumstantial evidence play very dominant role, and that is why in many a times even the DNA report standalone may be leading to, you can say, conviction. I tell you one important case which I normally refer. You remember the Panama Gate case where ex-Prime Minister Nawaz Sharif and his family was in prison. The matter in very nutshell, I just repeat that this family claimed to purchase a very high-end property in London, and the registered paper shown that the transfer of property on paper was in 2006. But when the investigation was carried out, it was found that the font used for typing the document for registration they were in Calibri font, and it was shown to be registered in 2006. And interestingly, Calibri font by Microsoft was released commercially in the market only in 2007. So this single piece of evidence corroborated the crime, and that is why the family landed into prison. So this is the beauty of circumstantial evidence. This Calibri font was corroborating that the person, or you can say the registered documents, were fabricated. The advantage, if you see, can convict without having direct evidence. So this is the very powerful, because many times criminals are very shrewd, very sharp, very intelligent, but still they leave some traces, and those traces, when they connect with each other in a systematic manner, they complete chain, and those small pieces, if we see them alone, they may not have any evidentiary value, but if they are being knitted in a chain, in a rope, then they complete the circumstantial linkage, and then you can reach to logical conclusion. So there are limitations, risk of wrong inference many times, need for stronger scrutiny, need just possibility of fabrication, and no eyewitness, hence you have to be very, very cautious. Now this is yet another important case, DPP versus Kilbourne, 1973, again House of Lords in England. Lord Seaman of Glasdale delivered the judgment. The fact was, Kilbourne was charged with indecent assault on a young boy. Prosecution relied upon the statement made by the boy to a local authority worker and conduct of the accused towards other children. So these were the two facts, the statement to third party and conduct of the accused with other children. So these were the two important points. Now here the key issue were whether circumstantial evidence and hearsay evidence, because means statement made by boy to a local authority, it was hearsay evidence, whether they can be admissible. The another legal issue was what constitutes relevant evidence in criminal trial. So the court held logical based probative value of the circumstantial evidence. So number one, the point was relevance of circumstantial evidence. Court said that evidence is relevant if it is logically probative or disprobative of some matter which require proof. Then there is no distinction between types. That means there is no rule that circumstantial evidence is inferior, meaning thereby circumstantial evidence may be very, very powerful. Mind it, because in most of the cases you may not get direct evidence, you may not get eyewitness, and very recently in Madhu lynching case, which I have discussed on our YouTube channel, you may go and visit again the YouTube channel which you are looking now or you are watching now. So there also the lynching was done publicly by multiple persons, but all eyewitness, they got hostile because of social pressure, various other extraneous factors. But the digital evidence, the videos, the other evidences which were being collected digitally, they were so strong, the probability was so grave that court at the trial level as well as high court level recently convicted all 14 accused. So this is the power of circumstantial evidence. Then admissibility of hearsay evidence. Hearsay evidence per se are weak, but if they become part of the chain, then even the hearsay evidence may play very dominant role. Now let us see a few cases in India. This is the most important case, the Panchshila circumstantial evidence. 5 guidelines were issued in Sharad Birdi Chand Sarda case of Maharashtra in 1984. I think for all students of law, whether they are the lawyers, judges and all, I think all must be aware of this case, the most important case, and many a times in exams, interview, even when you are contesting in the court or in argumentation also in normal circumstances. These 5 guidelines are the pillar of means propelling circumstantial evidence. So in nutshell, the circumstance must be fully established. The fact must be consistent with the hypothesis of guilt. The circumstance must be decisive. They must exclude every hypothesis but to establish guilt. If there is any doubt that he may or may not be guilty, then that circumstantial evidence cannot be accepted. The chain must be complete, the most important part. And if there is any breakage of any kind, then circumstantial evidence cannot be used for the purpose of guilty. And in absence of sufficient evidence, the person may be acquitted despite he may be actual guilty, but because of the evidence available, you have to acquit. Other notable judgment may be Vaishnav versus State of Chhattisgarh 2019. Here the court has squeezed 5 guidelines into 3. Then these are the list of latest cases. I don't want to go in detail, but those who may be law student may need more latest cases for various other purposes, for their court discussions, trial, appeals and all. They may use these cases, but they are very important, and I have put even the latest cases of 2025. The key takeaway, the importance in Panchshila and other cases you might have seen. The chain must be complete, that is first requirement. Proximity in time and space, particularly in last seen together theory. If you are using last seen together, then the time and proximity becomes very important. In these cases, corroboration is essential, discrepancy cannot be ignored if any, and interested witness need proof beyond reasonable doubt. Now let's go for United Kingdom, the another jurisdiction which is very prominent, and this is called rope analogy for circumstantial evidence. So this complete chain, or you can say rope, this theory was originated by this case called R versus Axel in 1866. So we have talked about Wilmington case in 1935, which is very important, and in our Indian context, Bidhi Chand case. But if you see this circumstantial evidence, I think rope theory or complete chain theory is most important, and this was derived by R versus Axel in 1866. Justice Pollock gave the rope analogy for circumstance that stand-alone evidence may not have any value, but they complete chain, then they become very powerful and reliable. So like rope or chain, the analogy is based on holistic reasoning, consistency and convergence. The facts are like strand in the rope. So single strand cannot be useful, but if they complete chain or rope, then that every strand has its evidentiary value, and in collective form they are very powerful. So R versus Axel, if you take murder case, so there are some examples, but ultimately it helps to understand one important point, that if you see the strand of a rope, so divide they may fall, but if unite they will have strong reasoning. So the power of collaboration may be said, divide one fall, united we stand, and this is the you can say you can use this analogy for circumstantial evidence to talk about doctrine of rope. The other judgment is Kilborn, and here also the key issue were whether circumstantial evidence and hearsay evidence are admissible, and that also gave relevance of circumstantial evidence. Here we have already given this discussion already. These are certain cases, DPDP versus CLB in 2023. So these are cases in last 2 to 3 years. So those who are interested may watch them, they can note down. So they are available on this YouTube. Now let us move to United States. Friend, the most important case in United States jurisdiction is Holland versus United States of 1954, where the legal issue was whether a conviction can be sustained based purely on circumstantial evidence, and this is most of the time this question arises, that can stand-alone DNA may be sufficient to award conviction. So this answer was addressed, or this legal issue was addressed in Holland in before the Federal Supreme Court of United States. The Supreme Court of United States held that circumstantial evidence intrinsically have no difference from testimonial evidence. So very powerful statement. They said that if the probative value of circumstantial evidence is observed and they are found acceptable, then they have equal status or equal weight like testimonial evidence, right? It must exclude every hypothesis except that guilt. This is, if you see the Panchshila given in Sard Birdichand, this point is the same. It must exclude every hypothesis except that of guilt. The evidence must prove guilt beyond reasonable doubt. The US Supreme Court propounded exclusion of reasonable doubt principle. So the exclusion of reasonable doubt was derived by Holland versus United States. So let us understand exclusion of reasonable doubt. For conviction based on circumstantial evidence, the court must observe and found satisfied that totality of evidence prove guilt beyond reasonable doubt. There are no other reasonable explanation consistent with innocence. That means there is no possibility of innocence, but there are only and only some possibility of guilt. Note, let us observe that Holland clarified that courts do not need to exclude every possible hypothesis of innocence, but only those hypotheses those are reasonable. That is also. So here I want to explain this sentence, very important, that means this point, exclusion of reasonable doubt, that prove beyond reasonable doubt or guilt beyond reasonable doubt, not beyond all reasonable doubt. That means possible or reasonable doubt. Thus Holland rejected older stricter standard for circumstantial evidence. It says it equated it with direct evidence and focused on reasonable doubt. So these are some latest judgments of 2025, 2024 and things like that. These are talking about due process, evidence aggregation and all. The key takeaway from United States jurisdiction: the gossip strengthens that circumstantial evidence often hinges on key testimony. Use of forensic evidence. Smith case emphasized constitutional challenge when forensic analysis is indirect, and then Holmes protect defendants' right to introduce contrary interference. Now this is the last jurisdiction, the fourth one, South Africa. The important case here is Rex versus Blom of 1939, where two-part inference test was introduced. And what does it mean by two-part inference test? The inference sought to be drawn must be consistent with all proved facts. Even if one inference is inconsistent, that means, like if you see the same thing in rope theory. Rope theory or chain theory was that even a single strand was inconsistent or there is a breakage in the chain, then that circumstantial evidence will not be acceptable. Likewise, that the entire chain of events, that must be intact. The second part is the proved fact must exclude every reasonable inference except one sought to be drawn. That means it should prove that the accused is the guilty. There should not be another hypothesis. So by and large, if we see, the focal point of circumstantial evidence remain same irrespective of the jurisdiction. The purpose of two-part inference theory was to ensure fairness and avoid speculative reasoning, to guide judges and jury in objective analysis of circumstantial evidence, and it applies in forensic evidence, cybercrime and others. These are certain latest cases which you may refer. The another list. The key takeaway may be Bohm doctrine. It gives two-part inference theory consistent with guilt and exclusion of other hypotheses. So these are the two takeaway: exclusion with guilt, consistency with guilt and exclusion from other theory, or you can say consistency with guilt and exclusion of innocence. So very simple. Then corroboration as logical integration. A rope analogy of United States was also adopted. Forensic evidence as circumstantial pillar. So these are the important point. Now let us compare. So I have made a comparative chart. Foundational case Sharad Birdi Chand R versus Excel. In US it were Holland versus US, and in South Africa Rex versus Blom. So these are the points you may note down whenever you get time. These points have already been discussed, but for the ease of your understanding, for the ease of your representing your exams, maybe just for in nutshell I have made. So I don't want to discuss it again and again. These are the jurisdiction contribution. If we see in India, what India has contributed. So the most important case Sharad Birdi Chand of 1984, where 5 golden principles were called out. In United Kingdom, R versus Excel, where rope analogy was put forth. In US, the Holland case of 1954, where equal footing with direct evidence was projected. And of course in South Africa, Rex versus Blom, where two-part inference theory was projected. So key takeaway, the first one is complete chain, which we have already discussed. You can say chain, you can say rope, you may say two inference theory and all. So they are almost you can say almost the central point is complete of the chain. Then proximity in time and space, particularly for last seen together theory. Then logical corroboration by motive, timing, witness, or maybe by forensics. No other hypothesis other than guilt. This is again a central point. And no discrepancy, free from reasonable doubt. So friends, that is how we conclude our discussion. So today I believe you must have understood the concept of circumstantial evidence, how they are important and significant for corroboration, and circumstantial evidence are integral part of our justice system. So with that I conclude my talk today. You may ask certain questions when you have time. You may go for chat box. I will be happy to respond. And now soon we will be starting a series for helping the LLB students, and I will take paper wise some important topics, so that our friends, those who want to learn law in a very simple list and mixed manner, where I will use Hindi and English language for simplification purpose. I will also talk there the elective paper forensics. So now very soon we will be starting the LLB, you can say paper wise series, and you can join it because now LLB is going to start and I want to make you more enlightened with means the simplest way of learning. Thank you very much. Namaskar.